Since the court's analysis focused on the Bruen case, I think it's worth taking time to review it here, starting with how the circuit courts have applied the SCOTUS precedent in regards to this law. Circuits have diverged in application of Bruen's framework. Many of our sister circuits have held that 922G1 is constitutional as applied to all felons. This is for United States v. Mansilla. Thus far, the 2nd, 4th, 8th, 9th, 10th, and 11th circuits have taken this approach. In Diaz, however, we recognize that 922G1 could be unconstitutional as applied to certain predicate felonies. So 6 of the circuits have found 922G1 to be constitutional. While the court often refers to Diaz in this opinion, like so many other courts, they place their previous decisions above the supreme law of the land. However, not all of the circuit courts have followed suit. Separately, the 3rd and 6th courts allow as-applied challenges to 922G1, and both circuits require district courts to make individualized determination of dangerousness when adjudicating these challenges. Courts in those circuits consider the person's entire criminal history, including the predicate offense and its underlying conduct. So just because a person is a felon, are they automatically considered dangerous? I've heard a report that claims the average American commits 3 federal felonies a day. It's an example of how the bureaucracy, accompanied by vague laws, makes felonies out of everyday life. However, the definition of a felony is a serious crime, not necessarily a violent one. The Free Legal Dictionary defines a felony as a serious crime characterized under federal law and many state statutes as an offense punishable by death or imprisonment in excess of 1 year. Before we get into the discussion of dangerousness, let's wrap up the Bruen discussion with a look at historical analogs. First, the government points to historical laws authorizing severe punishment for knowing possession of contraband, arguing that these laws shows that permanent disarmament of those convicted of possessing illicitly obtained goods today, like Hembre, is consistent with the Second Amendment. Hembre takes a narrower view of the historical analog. He cites that until a century ago, there was virtually no effective regulation of narcotics in the United States. The government points to historic severe punishment for the possession of contraband. But did that include depriving people of their rights protected by the Constitution? And according to Mr. Hembre, until a century ago, there was little if any regulation of narcotics in the United States. So how can there be a historical analog for this punishment?